Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. We have received some questions, some comments, some feedback regarding, number one, the massive amount of documents that were sealed from the public in Idaho versus Kohberger during the approximate 2.5 years that case was pending, from approximately December 29th, 2022 through July 23rd, 2025, the date of Mr. Kohberger's sentencing, when the court closed the case. The operative document governing this matter is the order regarding sealed documents that was filed by Judge Stephen J. Hippler on August 4th, 2025. If you read this order, you will note that the court has established a process to begin the consideration of unsealing documents. There's no guarantee that any document will be unsealed. The court is, in paragraph 1, giving the parties either the option of advising which documents they have no objection to being unsealed. Conversely, if there is an objection to a document not being redacted but continuing to remain sealed, the parties, that is the state of Idaho and the defense, are to, within 14 days, provide not just a rule of court authorizing the continued and possibly permanent sealing of documents from public disclosure. They must raise two things: legal authority, which might be what you've seen them raise in the case when they've gone to the court, both sides, asking for documents to be sealed, whether it's in a motion or in a stipulation. They may have raised the legal authority of a court case, either a case out of the state of Idaho or from federal courts if it had to do with, let's say, one of the constitutional amendments that we've seen cited in the case, or a citation to the state of Idaho Constitution or to the federal Constitution. And then factually, once they've identified legal authority that gives Judge Hippler the authority to continue to seal these documents, then they are required to provide a factual basis. That is, apply the facts of this case with specificity to this legal authority and explain to the court why the court should continue to seal these documents rather than, again, use the less restrictive means potentially of redacting. If they believe a document should remain sealed, they must identify why redacting of materials is not an acceptable arrangement, and with detail and specificity why the document should be sealed from both a legal and a factual basis. Now, this court order, as we see here, was served on the parties on Monday, the 4th of August 2025. So both sides have had a full week now to file if they have no objections to any of the documents that are here in what I call stage 1 for consideration of being unsealed. There's nothing on the case summary page and there is nothing on the court docket regarding any filing from either of the parties as to a non-objection, or for that part, if they have an objection. Now, they have until the 18th of August approximately. That's 14 days from the 4th. And coincidentally, the 18th of August was the start of the trial date that had been pending in this case, the trial that was canceled when Mr. Kohberger pled guilty, where the public would have expected to see the evidence from both sides, supporting their respective positions, supporting the state's position that Mr. Kohberger was the sole and the correct defendant responsible for the catastrophic events of the 13th of November 2022. On the other hand, Mr. Kohberger's evidence that he was, as he deemed for 2.5 years, not the correct defendant in the case. To see what documents are before the court in stage 1 of this process requires a review of this court order from the bottom of page 1 through page 2, page 3, and up to the top of page 4. Those are the documents. This is not going back to the beginning of the case. This is for the 2.5-month period that's identified here, from June 2nd, 2025 through July 24th, 2025. This case is not just 2.5 months old, however. There are the better part of 2.5 years more documents that apparently will need to go through this process. And it's unclear if Judge Hippler is going to wait until this first batch is dealt with before he submits an order regarding whatever the next set of documents that are currently under seal that predate this first item of June 2nd, 2025 on backward, or if he's going to wait until this is resolved and then move on to the next batch. Whichever way it happens, in my opinion, this seems like this is going to be a lengthy process. And for those that are interested in documents more towards the beginning of the case, it might be a matter of many, many months before the court gets to that. And finally, in my opinion, the comment that I give, there is no guarantee that any of these documents are going to be unsealed. We know that because the court's asking for objections. If there are objections, the court's going to have to make a ruling whether or not to continue to seal these documents, any one of them that there is an objection to, possibly even permanently from public disclosure. It's not just one side that requested this sealing of so many documents from the public. It's the state who's filed motions to seal, it's the defense who's filed motions to seal, and at certain times they together approach the court for a stipulation that matters should be sealed from the public in the form of documentation, including the massive amount of evidence that was asked for and responded to in the many motions to seal discovery's evidence that one party thinks is in the possession, custody, or control of the other side that they ask for in the discovery process. Take a look at the case summary page from the beginning of the case, and you'll see just how many documents that orders granting the relief, the remedy of sealing from the state, from the defense, or from both have been put in place from the beginning of the case. If you have any comments, any feedback, any opinions regarding this matter, please leave them here. And until next time, this is Kathy. Thank you for joining us here today.